Well, good evening, everyone, and welcome to what I hope will be the last bit of advice you need on GDPR, because hopefully most of you know what you're doing, and this is just an opportunity, a last opportunity, to ask a few last-minute questions and get any last-minute bits of advice you need. Now, we all know GDPR is coming into play on Friday. That means you need to have taken reasonable steps to have a GDPR policy and procedures in place by Friday. But it doesn't stop at Friday. Friday is when it starts. So from Friday onwards, you should be thinking about your GDPR policy. You should be making sure your staff are properly trained. You should be keeping an eye on how things develop, both in terms of your own business and what you read about from people like me. And you should be making sure that you are compliant going forward. GDPR is not something that you put in a drawer and forget about from Friday. Friday is the start, not the end. I'm going to read from some extracts from some of my notes. Some of it will be things that I've mentioned before. Some of it might be new things, and I'm hoping that as we talk, people will email in with any questions that they've got. I've got an extract, a quote from the ICO chairman, Elizabeth Denham, and I think it is extremely important that people know what her view is, because I think hopefully it will stop people panicking too much. She says, the first thing we are going to look at is, have they taken steps? Have they taken action to undertake the new compliance regime? We're not going to be looking at perfection. We're going to be looking for commitment. And I think that is very significant. I think there's a lot of people out there think that if they put a foot wrong come Friday or after Friday, they're going to be in a lot of trouble. That's simply not the case. Things are going to go wrong. People are going to accidentally send out an email to the wrong person. They are accidentally going to keep information perhaps longer than they should do. What will happen in those circumstances is somebody might report you to the ICO, and if the ICO considers that it's a potentially serious enough offence, they might come in and do an audit, or they might just simply ask you some questions. As long as you can show that you have tried your best to do everything you can, and you take on board anything that the ICO tell you, the chances of any significant consequences are very remote. So here are my top tips for complying with GDPR. Lawfulness, fairness and transparency. Personal data must be processed lawfully, fairly and in a transparent manner. Purpose limitation. Personal data must be collected only for specified, explicit and legitimate purposes, matter that is incompatible with that process. Data minimization. Personal data is adequate, what is necessary in relation to the purpose. Personal data must be accurate where necessary. Keep it up to date. Storage limitation. Personal data which is kept in a form which permits identification longer than is necessary for the purpose for which the data is processed. Integrity and confidentiality. Personal data must be processed in a manner that, through use of technology or organizational measures, ensures appropriate security, including protection against unauthorized or unlawful processing and against accidental loss, destruction, damage. Responsibility and compliance. Is responsible for and must be able to demonstrate compliance with all other data protection principles. Later, you are processing it, you need to make sure that you are keeping it for the right purposes, not keeping it any longer than you have to keep it, that you're keeping it safe. As soon as you don't need it anymore, you destroy it. Now, I've been asked a lot of questions about what amounts to personal data. Well, personal data is anything that can be used to identify you. So that's going to be your name, obviously, your home address, absolutely, your date of birth, your home telephone number, your national insurance number. Those are all things that are personal. What has been seen as a grey area is email addresses, and specifically work-related email addresses. And I have been advocating the fact that a work-related email address is probably not personal data. My email address, stephanie@kleymansolicitors.com, does not belong to me. If I leave the company, the email address stays with the business. If I were to be sick, for example, then they could just divert my emails to somebody else. I don't own the data that comes into that email address. And although it could be argued because it's my company, I do. That's a separate argument. My position as shareholder of the business is separate from my position as employee, director of the business. Therefore, it is not my data. In addition, the data is publicly available. So, for example, I received an email a couple of weeks ago where I was approached by the Times, who I have no contractual relationship with. I have subscribed to them, and they emailed me saying that they had obtained my information, my website, and from the Law Society, and they were contacting me because they wanted to conduct a survey. They made it clear where they'd got the information from, made it clear that I could opt out of doing the survey, but unless I did, they were going to carry on emailing me. I think in those circumstances, it's going to be very hard for me to argue that it's personal data and that by contacting me, they are in breach of GDPR. So all these people out there are using their databases without necessarily considering whether the data is personal, and if so, whether they actually need consent to use data. I think they're possibly going to regret it. Under GDPR, if you have personal data, so if you've decided that the you are looking at that's on your database is personal data, then you have 6 grounds on which you can process it. Now, obviously, the most obvious one is consent, but it's not the only one. And again, it's people who are deleting everything because they don't have consent, or they're emailing you because they think they need your consent. Some of them may be right, not all of them, because there are other grounds on which you can process data. You can argue under the basis of contract that is necessary for a contract you have with the individual, or because they have asked you to take specific steps before entering into a contract. So I think I might have frozen. Or if you're going to argue that you have the right to process data under the heading, a good example would be if you approached me and asked me to draft your terms and conditions, for example. We've entered into a contractual relationship, and I need to process that data in order to meet my contractual obligations to you. I can't, on the one hand, do what I've been asked to do, on the other hand, not process your data. So I have a contractual right to do that. And that contractual right would go on contract, because perhaps to bring a claim, and if I were to delete your data during that period, I then wouldn't be able to answer your questions. So if you contacted me within that 6-year period and asked me to delete your data, I would be perfectly within my rights to say, no, I'm going to retain that data, I'm going to carry on processing it for the purposes of that contract. The third heading is legal obligation. The processing is necessary for you to comply with the law. So that might be something like audit purposes, or it might be a requirement of your professional indemnity insurance, for example, or your regulatory body. I was asked today by an IFA whether he was had to keep information for a certain period of time, what he should put in his GDPR policy. And I said the first thing he should do is ask his regulatory body what they said, what their requirements were for keeping data, and then he would be perfectly within his rights to be compliant with that. Vital interest is the fourth heading. The processing is necessary to protect somebody's life. That's going to apply to people like GPs, perhaps counsellors. Number 5 is public task. The processing is necessary for you to perform a task in the public interest or for your official functions. And the task or function has a clear basis in law. Now, the final one, and I'm describing this as a kind of catch-all clause, is legitimate interest. The processing is necessary for your legitimate interests or the legitimate interests of a third party, unless there is a good reason to protect the individual's personal data which overrides those legitimate interests. Now, I've received a few emails recently from people whose database I'm on, where they are saying they believe that they have a legitimate interest for contacting me because I've given them my information previously, and I've received mail outs from them, and I've never previously unsubscribed, and they're going to carry on mailing me unless I say otherwise, and they're going under the legitimate interest banner. And I think they're absolutely right. I think it would be very hard to imagine a scenario where after Friday you phone up the ICO and say, I'm outraged, I'm receiving a mailing from somebody I didn't give express consent to. And the ICO are going to say, well, did you hear from them before GDPR? Yes. Did you have the option to opt out? Yes. Have you opted out? No. Then why are you calling us? They're going to be hugely oversubscribed. They're not being given any more funding to police GDPR than they had to police the Data Protection Act. You think of how much regulation has been involved, how busy they are likely to be at the moment. I hear at the moment it's an average of about 45 minutes to get through to their helpline on the phone. So what are the chances that they are going to have the time, the resources to investigate every single possible claim that I'm on your database when I shouldn't be? I think the reality is that they simply won't. So the biggest number of questions I've had has been about databases and the extent to which you can carry on sending out mail outs and blogs. And my view is that as long as you have a clear opt-out ability and as long as you obtain the data from a legitimate source, you haven't bought it from some dodgy organisation, I think the chances of any significant consequences from continuing to use it are very remote. Another question I get asked often is, what is processing? What amounts to processing? I think people are confused by this. I think they automatically assume that it means you're actually doing something with the data rather than simply storing it. So does sending your file to archives amount to processing? Well, yes, it does. The official definition of processing means any operation or set of operations which is performed on personal data or on sets of personal data, whether or not by automated means, such as collection, recording, organization, structuring, storage, adaptation or alteration, retrieval, consultation, use, disclosure by transmission, dissemination, or otherwise making available, alignment or combination, restriction, erasure, or destruction. Again, that's a pretty wide definition, and it's hard to see how anything is going to fall outside of that. So pretty much anything you do with data is going to amount to processing it. I had an interesting question the other day where somebody said that a client of theirs who printed catalogues was arguing that GDPR didn't apply to them because it doesn't apply to printed data, printed matter. Now, the problem they've got with that argument is anyone that you are sending the catalogue to, you're going to have to send it to their address. Well, their name and their address is personal data. So where did that information come from? Where are you storing that information? So it's the storage of those names and addresses that is going to amount to processing of personal data, and therefore that is what is going to amount to an act under GDPR. Going back to databases, I've got some points that might be helpful to people. So first of all, establish whether what on your database is personal information. GDPR only applies to personal data, not business data. So if you're only marketing to businesses, you may find that actually your database doesn't contain any personal data, in which case GDPR doesn't apply. If it is personal data, we've got the 6 grounds on which you can continue to process it. For example, if you have a contractual reason, legitimate interest, and you don't need consent. Assuming that you form the view that you do need consent, consider how you obtain the information in the first place. If you obtained consent at that time, freely given and not a pre-ticked box, then that will be sufficient. You don't need people to consent again. The only thing you need to check is whether you are using it for the reason you received it. So if you have people's consent to email them about updates in your services, you may not be able to argue that you have their consent to email them about networking events, for example. You can also consider to what extent the information you have is freely available online. I think it would be hard to argue that freely available information cannot be processed under GDPR. You can, of course, play absolutely safe and wipe your entire database, as I understand Wetherspoons did. However, I suspect it would be much quicker for them to rebuild their database than some of our businesses, and the publicity they generated from that act itself probably made it worth their while. Alternatively, you can email everyone for consent. And like me, I'm sure you've received many emails from people asking me to consent. Mostly they're saying you have to email back and say yes or no, which begs the question, what happens if I say nothing? Personally, I think you should either say, please say yes, or otherwise I will assume it's no, and I'll delete you, or please say no, or I'll assume it's okay to keep emailing you. GDPR does say that consent has to be expressed and you can't have pre-ticked boxes. So on that basis, the second option of I'm going to say you're in unless you ask to come out could be criticised. But if you go back to my scenario of phoning up the ICO, is anyone really going to complain about it? Finally, you can be brave and do nothing and see what happens. It's a bit like driving. I'm sure everyone has broken the law and driven too fast, occasionally, or parked somewhere where you shouldn't, or taken a chance on an amber light. Sometimes you get caught, sometimes you don't. Obviously, I'm not suggesting that anyone should deliberately break the law, but sometimes you have to make commercial decisions. If you have to make a choice between going a little too fast but getting to work on time, or sticking religiously to the speed limit and risk missing an important meeting or getting into trouble with your boss, you're going to weigh up the risks and decide which is the lesser of evils. The same applies to GDPR. It's a risk assessment. Only you can decide how much your database is worth, what the likelihood is anyone on it is going to complain about you, and what you think the chances are the ICO are going to want to investigate you. You might also like to take into account how prepared you are on other things in relation to GDPR. So Julian has asked, how do you prove existing consent? Do you need a signed contract or similar? No, you don't. Obviously, the more evidence you've got to prove consent, the better off you are if there is going to be an issue. Something signed is perfect, but it doesn't have to be. So, for example, if somebody, I was advising a call centre recently, and we came up with a form that the call centre operators would fill in as part of their regular script, and they would ask, do you give consent? And the person would just fill in the bit on the screen where the person had given consent, and that would be sufficient. Yes, you're always going to have the risk that someone might say, no, I didn't. But if you've got a clear record of the person having been asked and given their consent, then I think it's going to be quite difficult for the ICO to say you have done wrong. So you've asked for consent, it's been given verbally, you've kept a note of it, and the minute you became aware that they'd changed their minds or they didn't think they'd given consent, taken the appropriate action to remove them from your database, if that's appropriate. If you form the view that you need to keep that information for ongoing contractual purposes or ongoing legal purposes, then you're still entitled to do that, even if somebody has withdrawn consent. So, Julian, I hope that answers your question, but do let me know if you got anything further. People have asked a lot of questions about consent, so as Julian has, so perhaps this is the time to talk about what is consent. GDPR defines consent as a freely given, specific, informed and unambiguous indication of the data subject's wish by which he or she, by a statement or by a clear affirmative action, signifies agreement to the processing of his or her personal data. Now, we do know that pre-ticked boxes are not acceptable. If you're going to look for people's consent in an electronic format, it has to be a box that they tick. But we're not sure at this stage to what extent implied consent is going to be valid. So it may be that there will be an argument for saying that if you're at a networking event and somebody hands over their business card to you, that there is sufficient implied consent, and that is a sufficient affirmative action for their data to be processed. But you could ask for them to. I went to an event recently where they asked me to write on the back and say that I confirmed that I gave them my permission to process my data. Personally, I think that's a little bit OTT, but that's what made them happy. Silence, pre-tick boxes, or inactivity should not normally constitute consent. When the processing has multiple purposes, consent should be given for all of them. Data subjects have the right to withdraw their consent at any time, although this will not affect the lawfulness of any processing carried out before the withdrawal. And I think, as I've already said, just because somebody withdraws their consent doesn't mean you automatically have to delete your records. You have to decide whether your need to keep those records overrides their request to be forgotten. Now, most people I deal with have staff, whether that's employees or workers or subcontractors, self-employed people. Mostly we all work with other people in one capacity or another. That means that you are going to have the personal data of other people, and how you process that data is important. The reason for that is it's likely to be more personal, more sensitive perhaps, than the people you do business with. You might have information about medical issues, you might have information about previous jobs, you might have information about race or sexual orientation, and you might have bank account details. These are all things that you need to be more careful with. Employers may process employee personal data if the processing satisfies one of the several justifications. In addition to employee consent, employers may process employee personal data if the processing is either for the performance of an employment contract, for compliance with the employer's legal obligations, to protect the employee's vital interests, for carrying out public functions, and for the legitimate interests of the employer or a third party. Here are 8 things you need to know. Consider processing personal data in a way that you can't tell it from the person it relates to. So if you've got a large workforce, you might decide that instead of protecting or limiting who has access to the data, you might edit the data itself. So instead of people being identified by name, you might identify them by a number. So every employee has, for example, a payroll number, and then anyone who picks up their file and sees information about them won't know who that information relates to, and therefore that might protect you from GDPR. Think about whether some of the data can be anonymized. Do you really need to be able to identify the employee to use the data? For example, if you're processing information for research or statistical purposes, then you can anonymize it. We see this a lot in the public sector when data is collated for the purposes of equal opportunities. So that might be another way in which you can continue to hold employee data, but without it becoming public. When you're dealing with all personal data, but particularly employee personal data, use passwords and encourage employees to use more complex passwords, not to share them, and to change them regularly. And on that subject, control of electronic devices is essential. Now, there's a number of things you should consider. Firstly, you should be talking to your IT support company and making sure that you have the necessary software and protection in place to reduce the risk of being hacked. I understand from people who understand these things much better than I do that the probability is we all get hacked or attempt at hacking from time to time. So you're never going to be able to prevent it altogether, but you need to take all reasonable steps to make sure that you are protecting your data as best you can. You also need to think about what steps you are taking to make sure that equipment that is used is safeguarded. And that's not just in terms of data, in terms of software and passwords, but also what controls you have about where the equipment is. So, for example, are your staff allowed to take laptops home? What safeguards do you have in place to make sure that if they take your equipment home, they are the only ones that are using it? Do your staff have the ability to download information onto their personal laptops if they're going to work from home? So Laurel's asked a question. If you take something like MailChimp, people give their consent, so you add them to your list. Then when they want to unsubscribe, they can write that they never signed up for the list. Do you think, like MailChimp, that a number of people would have to complain as opposed to a one-off complaint before action is taken? Do you mean one person complaining, lots of people complaining about MailChimp, or lots of people complaining about you personally adding them onto your database? I think in order for the ICO to be investigating any particular entity, they're probably it's either going to have to be a lot of people complaining or one big data breach. So something like Barclays Bank being hacked, I think that could lead to an investigation. I think if people are going to complain to the ICO about you, I think if they just got one or two complaints about you being on their mailing list, I think the ICO probably wouldn't take it too seriously. But I think if 50 people phoned up, 20 people phoned up in a very short space of time, I think that might start flagging up. If lots of people are saying, I never consented to being on her database, I think that's something that the ICO would investigate. And of course, if everyone said, lots of people say, I didn't consent, that's going to be hard to argue with. If you've got 2,000 people on your database and only one or two say, I didn't consent, then I think it's less likely that the ICO are going to take them that seriously. We were talking about equipment, and I was suggesting that if people are using their personal computers, that you need to make sure that they are careful what they are doing when they are outside of the office. Anyone who works for you, not just employees, subcontractors, self-employed people, workers, temps, they should sign a confidentiality agreement, something that makes it clear what you consider to be personal data and what they can do with that personal data. It shouldn't just be a document that they sign and goes in a drawer. There should be training, and there should be records kept of who you trained, when you trained them, how long the training took. You would be keeping records to show that when new people joined you, they were trained properly, to show that when people left, you were reminding them what their obligations were. You should have records to show that when somebody leaves, if they used your equipment for personal purposes, you have wiped all their personal information from your equipment, and something to make sure, as far as is possible, that if they use their personal laptop or iPhone or iPad for work-related purposes, that you have taken all reasonable steps to make sure that any personal data on that equipment has also been wiped. You also need to make sure that staff are aware that if they become aware of a breach, that they notify you. So, for example, if any equipment is lost, if they become aware of a hack, or if they are aware of the fact that they've accidentally sent something out to the wrong person, that they bring this to your attention. It doesn't necessarily mean that you have to rush to action it, because it will depend on the circumstances. But if you get them into the habit of letting you know something has gone wrong, you keep a record of it, then if you were unlucky enough to have an ICO investigation, these are the kinds of things that they are going to look at to be reassured that anything that goes wrong is an accident, a one-off, rather than a general culture of we don't care about GDPR. So going back to my list of points specifically about employees, but can also apply to other aspects of personal data. Encrypt data where possible, particularly if you are transferring data or allowing remote working. I read that the police were recently fined £150,000 for allowing a disk of information to go missing. if they had encrypted the data on that disk, then the chances of any serious repercussions would have been limited because no one would have been able to access the information on the disk. However, I was asked recently whether it was true that all information now has to be encrypted. A woman I was giving a talk to said that she had been told that it was now obligatory under GDPR for all emails to be encrypted. And I asked her who had told her this, and she said a company that sells email encryption. So my view is no, you don't have to. It is a risk assessment. All aspects of GDPR are a risk assessment. You have to weigh up the risk of a breach versus the cost. I think I might have frozen again. I don't know if anyone can still hear me. Hopefully I've unfrozen. It's not just about the cost. To say I didn't do something because I couldn't afford it, I don't think would work. But I think it is reasonable to say I weighed up the risk of a breach versus the cost of avoiding that breach and decided that the cost outweighed the risk. And I think the ICO would recognise that. And I think it's important that you record in your GDPR policy the fact that you've considered the risks and reached a conclusion. If anyone is investigating you, then these are the kind of notes that are going to be invaluable. So only process personal data that is necessary for a specific purpose. Put in place measures to ensure you are compliant with the principles. Keep records to prove you are compliant. GDPR generally prohibits employers from processing employee-sensitive personal data, subject to the following exceptions. Explicit consent, but I think you need to think carefully about consent in an employer-employee relationship. If somebody's been with you for a long time and they've got a good job, they might not feel able to refuse consent. They might be worried about their job, they might be worried about their future with you. So I think you need to, just because somebody consents to something, that might not be sufficient. The processing relates to personal data that the employee has made public. The processing is necessary for the employer to carry out specific rights and obligations in the context of employment law or laws relating to social security and social protection. To protect the vital interests of the employee or another person, and the employee is incapable of giving consent. For establishing, exercising, or defending legal claims. For reasons of substantial public interest, including archiving purposes, and for historical, scientific, research, or statistical purposes, subject to appropriate safeguards. Now, we've talked about GDPR in the context of people who work for you, but it's also very relevant when you are recruiting, whether you are doing it directly or whether you are doing it through an agency, or if you are an agency, you're obviously going to come into contact with a lot of personal data, and how you look after it, how you handle it, how you keep it is obviously going to be something the ICO would look at if you were ever going to be investigated. So you need a candidate's express consent when processing special categories of data, such as race, sexual orientation, religious belief, health data, or information on trade union membership. So if you're going to ask people to fill in some kind of application form, you might want to think about having some kind of declaration at the bottom of the form saying they consent to the processing of special categories of data. Do you have an equal opportunities policy? I'm sure you're all out there saying, yes, yes, of course I have an equal opportunities policy. Well, if you don't, now is a good time to get one in place. Whether you're doing one or updating it, make sure that your consent statement covers processing for monitoring data and diversity statistics, as well as processing it for the purposes of recruitment and selection. Now, social media has started to play a very big part in recruitment recently, but GDPR comes in here too. Individuals have a right to privacy over their publicly available information. Tell candidates, such as in a privacy note or on the application form, that you reserve the right to review publicly available information on them. Applicants have a right to object to you processing such data. If they do, you shouldn't then process any data about them that you find on social media. So, for example, don't take copies of it. If they don't object, then you, rather than actually consent, if they just don't say anything, then I think you can rely on legitimate interest as your grounds for processing the data. The guidance implies that recruiters should only review social media and similar information if there is a specific risk arising from the specific role. But that guidance is just guidance. It doesn't have any specific legal implications. And I think that's quite important when we consider what the ICO is telling us. I'm not for a moment doubting the advice they are giving, but I think it is important to remember that at this stage it is just advice. And until the GDPR comes under the scrutiny of the courts, we don't know for certain how a lot of it is going to be interpreted. It's a little bit like the police often get prosecuted, or HMRC often go to court. That's because HMRC will say, we think this tax is applicable, and the individual company will say, no, we disagree, our accountant says differently, and they go in front of a judge, and the judge has to make a decision. Well, this is no different. Just because ICO might come along in the future and say, we think you should have done this or shouldn't have done that, doesn't automatically mean that they are right. And there is the possibility that the larger organisations will challenge them, and until we get specific rulings on things, it may be that we don't know for certain how it's going to be interpreted. Deleting data. This relates specifically to recruitment. Don't keep recruitment data for longer than is reasonably necessary. Bear in mind, you have a legitimate interest in keeping records about runners-up in case the successful candidate doesn't work out and you need to recruit again. And you have a legitimate interest in keeping data to protect yourself against discrimination claims. How long should you keep information about unsuccessful applicants? Well, again, do a risk assessment. You could review it at the end of each recruitment round, or at least for recruitment generally, and review it every few years. But overall, a general rule of keeping data should be for about 6 months in recruitment terms only, as long as this is included in your privacy statement or on the application form. That would be likely to be seen as reasonable. If you then delete the data in accordance with what you've told candidates, and that candidate then made any kind of claim against you out of time and wanted an extension of time, it would be much easier for you to object to such an extension of time, because you could say, well, you deleted the data in accordance with your GDPR policy. If you're a recruiter, or you had somebody's CV for recruitment purposes and you've circulated it to somebody else, such as to a colleague or to a client, then if you're deleting the data under your GDPR policy, you should consider whether you should tell them to delete it under their GDPR policy. Now, a lot of people are very stressed about GDPR, and I do understand that there's a lot to take into account. But I think you should see GDPR as an opportunity, not a hindrance. This is an opportunity to overhaul, review all your policies and procedures, and make sure that you are compliant. Our data, all of our personal data, has a value. You wouldn't want anyone misusing your data, so you have a duty to look after your employee, clients, and contact data. So when you're having your review, also review your contracts, not just from a GDPR point of view, but from an employment point of view. Have a look at your staff handbook. Again, does it have a GDPR policy in it? Does it have a privacy policy? If not, now is a good time to update it. Have a look at your privacy notices, not just for GDPR purposes, but are they fit for purpose? Does it work within your business? And look at consents. What consents do you have? What consents do you need? Let's move on to the rights of data subjects. We are all data subjects. We all have data out there. And this is important not just from how you look after the data that you have within your business or organization, but considering how other people might have data on you and how you might want that to be protected. So a data subject is identified as the identified or identifiable person to whom the personal data relates. I think we can all agree that's us. Enhanced rights for data subjects under GDPR include the right to correct data about them, which is wrong, the right to restrict certain processing, and a right to be forgotten or erased. So under the Data Protection Act, if someone wrote to you and asked you for a copy of all the data that you were holding on them, you would have the right to say you weren't releasing any information unless they paid a fee of £10, and you then had 40 days to provide that information. Well, under GDPR, you only have 30 days and you can't ask for any money up front. The first request for information is free, but if they come back and make a second request, so they've lost the papers or they want the papers again, at that point you are entitled to make a charge. There is no prescribed fee. It's up to each individual business to decide what is reasonable for them to cover their administrative costs. I would be suggesting that you want to be putting a figure in your GDPR policy, so it's not a figure you've just thought of off the top of your head, but it is something that you can genuinely relate to your actual costs and say how you've reached that figure. So you might say, for example, that it would be half an hour of a member of staff's time, and this is what their hourly rate is, and so that's how you've reached that figure. You also need to have in your GDPR policy how you are going to be reassured that a person making a request for a copy of their file is the person that they say they are. Obviously, if somebody writes to you and says, I want a copy of, I am Stephanie Kleyman and I want a copy of her file, well, if you hand out a copy of my file without having checked that they really are who they say they are, then you would automatically be in breach of GDPR. So each business obviously is different. You have to come up with a policy that works for you. So if you have something that's got my signature on it, then you could say you want something from me on a piece of paper, not an email, that has my signature on it. You can then compare it to anything you've got from me that's got my signature on it and satisfy yourself that it's from the right person. But what if you don't have something that's got my signature on? These days, we don't put that much in writing. We don't sign letters that often. So you might not have something from me that's got my signature on. So in those circumstances, your options are a certified copy of my passport, certified copy of my driving license, or you could ask that I come in and have a meeting with you so that I can prove that I am who I say I am. Whatever your policy is going to be, it needs to be in your GDPR policy and it needs to be in your privacy policy, and you need to be able to justify it. So, for example, if you did have somebody's signature, if you could prove what their signature looked like, and you then said you wanted a certified copy of the passport, you would need to justify why you were asking for the passport when a signature might otherwise have done. So, how to help the exercise of data subject rights. To satisfy your obligation under GDPR and help the exercise of data subject rights, you should take several steps, including, but not limited to, the following. Implement internal procedures and protocols to help the exercise of data rights. So that's making sure that people know what terms need to be satisfied in order to provide a file. Reviewing and revising policy notices, so making sure it remains fit for purpose. Implementing internal procedures and protocols for handling and responding to data subject requests in a timely and appropriate manner. Implementing an authentication process to verify the identity of data subjects. Developing template response letters. Developing forms to collect additional information where necessary for preparing data subject request responses. Creating an inventory or log for recording data subjects requesting and for tracking responses. Providing a mechanism for data subjects to directly update or correct their personal data. Now, I think here you might want to be a little bit careful because there may be some circumstances where just because somebody tells you, oh, I've moved or I've changed my name, you might want to have that verified. Depends on what industry you're in. It depends on why you have that information. But if I look at my business, for example, if I was issuing proceedings on behalf of a client and halfway through they got married and changed their name, I would want a certified copy of a marriage certificate. I would need verification of the change of name. And that would be written into my GDPR policy. Now, that might not apply in your businesses, but you still need to think about, do I need evidence of a change of name or a change of address? If so, why? And what information would I ask for? What evidence would I want? Consequences of breaches. This is the bit that always worries people. It isn't as scary as it sounds, but I do understand that they're big figures. If there is a breach, the company guilty of a breach can face sanctions with the maximum fine limit for the most serious case of up to 20 million euros or 4% of an organisation's global turnover, whichever is the greater. Some contraventions will be subject to administrative fines of up to 10,000 euros, or in the case of undertakings, 2% of global turnover, whichever is the higher. Now, here's the important bit. Administrative fines like these are discretionary rather than mandatory. So there's going to be a huge amount of discretion before anyone could implement fines at those kinds of levels, and those are going to be aimed at big organisations with huge amounts of data who are guilty of serious breaches. It's not going to apply to small organisations like us as long as we can show that we have taken all reasonable steps to be compliant. If they're going to be implementing fines, they're going to be processors are only going to be liable if they have not complied with any of their obligations under GDPR, have acted outside or contrary to lawful instructions. So if you get hacked through circumstances completely beyond your control and you had taken all reasonable steps to make sure that didn't happen, the chances of a fine are very remote. Any person who has suffered damage as a result of infringement of GDPR has the right to receive compensation. Under the Data Protection Directive, liability for compensation is limited to controllers only. I'm interested to see how this is going to play out in practice. What they're effectively saying is, let's say my bank has a hack and somebody gets hold of my data, my bank account details, and then hacks my bank account, or uses my credit card. In order for me to bring a claim, I am going to have to show that it was the hack at the bank that was a direct cause of my credit card being misused. As a litigator, looking at how we prove loss, that is a very big jump, proving one led to the other. And I'm going to be interested to see if anyone is actually able to bring a claim under this regulation. I don't think it's nearly as easy as it looks. Where an accidental breach of personal data has occurred, data controllers must notify most data breaches to the ICO. And when it says most data breaches, what it means more serious breaches, a minor, not something that the ICO is going to be. Data processors who suffer have an obligation to notify the relevant controller. In both cases, this must be done without undue delay, and where feasible, a controller should notify the ICO within 72 hours of awareness. When deciding whether to impose an administrative fine and deciding on the amount of the fine, due regard is given to nature, gravity, duration, intention or negligent characteristics of the infringement, the action taken by the controller to mitigate it, degree of responsibility, any relevant previous infringement. So is this a one-off, or have you been guilty of it all day, every day for the last 5 years? Any relevant, the degree of cooperation that you give to the ICO, category of personal data affected by the infringement. So obviously things like bank account details, sensitive personal data like that is going to be considered much more serious than just somebody's name. Adherence to approved codes of conduct, any other aggravating or mitigating factors applicable to the circumstances of the case. So in other words, they're going to take everything into account, not just looking at the breach in isolation. So how can your business show compliance? To comply with GDPR and demonstrate compliance, you must embed data protection measures into corporate policies and procedures and day-to-day activities throughout the organization. This means implementing internal policies and procedures, including an organization-level data protection policy on handling personal data, which should include, but not be limited to, policies and procedures on collection and use of sensitive personal data, Collection and use of personal data, particularly about children and minors, including obtaining parental consent. Secondary uses of personal data, maintaining data quality, anonymizing or pseudonymizing data, processing personal and secure destruction, security breach management, using personal data for direct marketing, using personal data in research, information security, including the specific measures. Data controllers must not only maintain internal policies and procedures, but must ensure that it integrates data protection measures into the organization's practices and that employees follow the policies and procedures in their day-to-day activities. I think a big part of GDPR is not just about what you do, but what you ensure that anyone working with you or for you does. So it's not just your employees, but workers, temps, self-employed people, external people such as your bookkeeper, your accountant, possibly even your solicitor, making sure that they are compliant. If you are letting anyone else access your data without taking steps to make sure that they are going to be as compliant as you are, then all the GDPR policies in the world are not going to protect you. To help ensure that policies and procedures are fully followed, organisations should implement regular training and use testing, audits and other documented mechanisms to measure and demonstrate compliance. So you should have somewhere in your GDPR policy how regularly you are going to review this and what a review is going to involve. So I'm going to flick through it once every 6 months, or is that once a year the board and I are going to sit down and work through it and ensure that it is still compliant? So there are two things that are going to happen. Going to evolve and your business is going to evolve. If you think about the extent to which we used social media and the internet 10 years ago, very few businesses needed a social media policy, the extent to which we use social media during the workplace. These days, everyone uses social media all the time, and I would say every business should have a social media policy. Well, GDPR is the same. It is something that is going to evolve over a period of time as it is implemented and we start to understand how the ICO and the courts are going to interpret the regulations, but also because how we operate as an industry, as we operate as businesses, is going to evolve over a period of time. Business is going to evolve. You might only be a one-man band right now. 5 years from now, 2 years from now, you might have staff and you might have and procedures, and you might have a large amount of data, and that might affect your GDPR policy. So GDPR should not be seen as something that you just draft and put in a drawer. This is something that is a living, breathing, existing regulation that should be watched on a regular basis. So here are the main things that I think you should take away from this talk. Map out what data you hold on customers, contacts and employees, where it comes from, how it is stored, who can access it. Now, where it comes from, I think, is important if you're using data that is supplied by third parties. So there are businesses out there, I know, that buy databases. I think that's possibly a little dangerous these days, but I know it's still. So you need to think about to what extent you are at risk if you find that you are processing data that the person did not give consent for. So there are a number of ways in which you could deal with that. You could ask the person that you are buying it from to indemnify you and to certify that it is legitimate, because people do sign up to things legitimately. Or you can consider taking out some kind of insurance policy. I understand that there are organisations out there that will give you insurance. You can insure against pretty much anything, but you can insure against a GDPR claim. Having said that, your insurer might say that database from an disreputable organisation, then they wouldn't provide you with cover. How it is stored. So we talked about making sure that you spoke to your IT support company, had all the relevant software in place so that you were less likely to be hacked. But you also need to think about what equipment is being stored on, where that equipment is being stored, who has access to it. I have a client who was asking me the other day, he has a server, all his information is stored on a server, which is in the basement of his building. He's on the first floor. Other people have access to the server. His IT support company did a very expensive mechanism for boxing in this server so that no one else could access it. However, it turned out that there are CCTV cameras that look at server so that if anyone did approach it that didn't have authorization, it would be recorded. It also turned out that very few people have access to the room because there are very few keys. So I suggested all they really needed was a process for making sure that nobody could take the key without permission from a director. And so in reality, the server wasn't readily available. So where is your data being stored? Who has access to that data? What training have you put in place? Can you limit who has access to to limit your exposure? Think about why and how elements you have and whether you need them. Is there any data that you can delete? You might need to keep data for 6 years, but do you need to keep all the data? Is there any data that you have that you can delete? Can you anonymize it so even if it did fall into the wrong hands, it would be meaningless to whoever accessed it, and so you are protected? Understand the gaps in and knowledge and specialists to plug them. So that might be IT support people, that might be people like me who will help you come up with training packages and GDPR policies that will provide you with more protection. You need to be thinking about confidentiality agreements and non-disclosure agreements to try and keep your data as safe as possible. Plan ahead. Now, when I wrote this, it was plan ahead for May. Of course, we're only now a few days away from GDPR, but that still means plan ahead because Friday is the start and not the end. So you need to be thinking about what you are doing in your business, say over the next 6 months to a year, what data protection issues might arise and how you might want to protect yourself from those. Alison has asked, if a client who works as an employee, if I have a client who works as an employee in a large corporate and I haven't done any work for her for a few months, do I need permission to keep her work email address? This constitutes personal data. I've mentioned previously, my view is that work email addresses are not personal data. They don't belong to the individual, they belong to the company. And if the only purpose of emailing them was work related, then I believe that that is not personal data. If you are going to continue to use it, so even if it was personal data, you don't necessarily need their consent because you can say, for example, that you have a contractual right or a legitimate to continue that data. And you've said, I haven't done any work for her for a few months. Well, that doesn't mean that you might not do work for them in the future. You might need to keep their data in relation to some of the work that you have done for them previously. If it's a contractual relationship, they've got up to 6 years to bring a potential claim against you if they think there was anything wrong or to raise any queries. So I would be saying legitimate interest or contractual right and keep the data, including the email address, for up to 6 years. Hopefully that helps. So plan ahead in terms of what new data might come your way over the next 6 months. Doing some kind of marketing campaign perhaps, and that's going to generate more interest in your business. How are you collecting that data? Storing it. Well, I think I've pretty much come to the end. Thank you everyone for all your questions. I hope I've answered everybody, but if anyone does have any more questions, they are very welcome to email me, for a copy of my notes. I'm Stephanie at KleymanSolicitors.com, and I hereby on record give you permission to process in the form of my email address. You're welcome to email me about anything. Thank you very much.